Welcome to Criminal Law Video Presentation 12. This video presentation will cover attempts. To begin with, let's go through a little example. So we have our fellow here with the baseball hat with the gun, and he's thinking to himself, I intentionally got this gun to shoot the professor, and I've come to his office to do so. And then he continues to think, I intend to kill the professor, and I know he is in there. So at this point, the question becomes, has he committed a criminal offense of any sort? This is where attempts come in. Now, to begin with, whatever is going to be attempted, there must be a target offense. You must attempt to do something. So it's attempted murder, as in this case. It could be attempted theft. It could be attempted burglary, but attempts don't stand on their own. So there are several questions that we're going to have to resolve in order to decide if an attempted crime has been committed. The first of these we're going to discuss are what's revealed in the little balloons that he's thinking. That is his mental state. The second issue that we're going to talk about is what conduct is necessary to bring about an attempt. So that's what I put up here, what remains to be done, because an attempt, as you will see, is a crime that has not been completely completed, that is not complete in and of itself. So let's go on and start to look at this. Okay, at common law, the mens rea for attempt was intent to engage in the conduct that constitutes the actus reus of an attempt, and we'll talk about the actus reus in a minute, and the intent to commit the target crime. So there's two intents here, as we see, and if it's a result crime, the actor must intend the result. So you cannot commit an attempted felony murder or an attempted reckless murder. As a result of these two required mens rea, the intent to engage in the conduct and the intent to commit the crime, attempt is a specific intent crime. All attempts, attempted burglary, attempted theft, attempted rape, attempted murder, are all specific intent offenses. Going on, let's talk about the Model Penal Code for a minute now. Model Penal Code attempt is under section 5.01, and we're going to see that what the Model Penal Code does is to divide attempts into those that are completed. That means that there is nothing more for the actor to do and still a crime has not occurred, and to those that are incomplete, that several steps away from completing the offense. And you'll see some examples as I work through this. So with conduct crimes, the section that's going to be relevant is 5.01 parens 1a. With result crimes, it's going to be 5.101 parens 1 parens b. With incomplete crimes, whether they're conduct or result crimes, there will be two sections that will come into play. 5.01 parens 1 parens c and 5.01 parens 2. Okay, so let's see what the Model Penal Code does with each of these. Okay, so first thing that is required, acting with the culpability required for the commission of the target offense. That is going to be necessary for all three types of attempt under the Model Penal Code. Okay, the first section that's relevant is 5.01 parens 1 parens a, purposely engages in conduct that would constitute a crime if the attendant circumstances were as he believes them to be. So in this instance, one has to purposely engage in conduct that would constitute the entire offense here if the facts are as the defendant believes them to be. If that would be, then it would be a crime. The second one, 5.01 parens 1 parens b, purposely causes or with the belief that it will cause such result without further conduct on his part. This is doing everything he can do and still does not cause the result. And then you get to 5.01 parens 1 parens C, purposely does or admits to do an act under circumstances as he believes them to be, that is a substantial step in a course of conduct planned to culminate in the offense, as can be seen here. And I'm going to talk about this C a little further later on. But as you can see here, with all three of these, you need the culpability required for the commission of the offense, and then whatever conduct the defendant engages in that will constitute an attempt, that conduct must be done purposely. Or if there is a completed result, that result must be done purposely. So again, must be the conscious object purposely to engage in conduct, purposely or with belief that conduct will cause a result that would constitute the substantive offense. This is for both completed offenses. And finally, purposely engage in a substantial step. This is the one that's incomplete, as we'll see in a few minutes. Okay, so let's summarize this pretty quickly. And as you'll see here from this chart, which is slowly coming into being, that with, I've laid out here common law intent as to conduct, common law intent, purpose, and sometimes knowledge as to result, and then as to attendant circumstances, whatever is required for the target offense. Pretty similarly, the model penal code follows this. So conduct has to be purposely, it has to be purpose or belief about bringing about the result, and then again, whatever the target offense requires for attendant circumstances, that is what the defendant's mental state must be when attempting to commit that target offense, as we see here. Let's go on now. Let's talk about now the actus reus for attempt. As you're going to see, unless we are talking about essentially a completed attempt, doing everything that one can do and still not complete the crime, the law of attempt as to the actus reus is going to be an issue of really line drawing. How close has the defendant come to the target offense that, as a matter of policy, we are going to punish the defendant for an attempt to complete that offense? So, you know, the reality is that the defendant must go, the courts will often say that the defendant must engage in conduct that goes beyond mere preparation and it is proximate to the completion. So you'll see language in cases that say it must go beyond mere preparation into perpetration, into proximate to the completion. But essentially what the courts are striking at is to get beyond just preparing to commit the offense and crossing some imaginary line where the defendant should be punished for what the defendant has done, even though the defendant has not completed the target offense. So in some instances, courts will ask, how close has the defendant come to completing the offense? And in many instances, you'll see he must come dangerously close. Okay, so let's take a look at the various line drawing attempts, and all of these are going to cause you some degree of consternation as we work through them. There are about 5 or 6 different tests that courts lay out. You will see in some of the cases the courts combine the tests, the courts use several different tests, and it's all in the desire to create some line over which the defendant must cross in order to be guilty of an attempt. The first of these is the last act test, and just as it says, the person performs all the acts that she believes necessary to commit the target offense. There is nothing more to do, and yet the target offense is not completed. And, you know, the best example that I can think of is gun to the head, pulls the trigger, and doesn't kill the victim. Begins to remove the painting from the wall, and, you know, is there touching the, holding on to the painting, but it's still on the wall. So the question becomes, That's obviously an attempted theft. Starts a fire, starts some kindling to burn in a building and then gets caught, or the fire goes out or whatever, that may be an attempted arson. So the last act test. There's another test called the res ipsa loquitur test, which is borrowed from torts, and it's called also the unequivocality test. The act does not constitute an attempt until it ceases to be equivocal. Person's conduct alone unambiguously manifests a criminal intent. You'll see this played out in the Miller case in your book. In addition, buying matches to burn the hay, a court will find, is not an attempt. Taking the matches to the haystack and lighting one of them may be an attempt to burn, and therefore may be an attempted arson. But you see, once the actor has lit the match and thrown it into the hay, or lit the match with the hay right there, the courts are willing to find an attempt under the res ipsa loquitur test. Probable desistance test, just as it sounds. The actor reached a point where it was unlikely that he would have voluntarily desisted in his efforts to commit the crime. You have to identify a point, essentially, of no return of an ordinary person in the actor's shoes. Induces a boy to the house, meets him as he gets out of the cab. Courts have found that this is an attempted lewd and lascivious acts. Alters prescription from 1 to 11, fills the first, and is arrested. In this instance, a court found that based under the probable desistance test, it was not an attempt. As you can see, some of these are very picky and don't offer a lot to go on. Indispensable element test emphasizes an indispensable act of the criminal endeavor over which the actor has not yet acquired control, not yet acquired the instrumentality of the crime. So again, doesn't have the gun for a murder or the equipment to manufacture illegal drugs. In this instance, if a court is using this test, they're going to find that an attempt has not been completed. Dangerous proximity test. So near to the result that the danger of the success is very great. Nearness of the danger, greatness of the harm, degree of apprehension felt are all factors that courts are going to consider when applying this test. So orders cocaine, supplier brings to her home, examines and rejects on quality grounds. The court in this instance found an attempt. Will buy drugs when obtain money, schedules a meeting to buy, is arrested. The court in this instance, using the same test, did not find that there was an attempt. Physical proximity test. Again, very similar to the one that I just indicated. Proximity to the completed crime must approach sufficiently near to it stand as either the first or some subsequent step in a direct movement towards the commission. Actor has it within her power to complete the crime almost immediately. Weapon in hand, victim in view, can immediately proceed to rob her absent external factors. Again, in this instance, the court found an attempt based on the physical proximity test. Okay, let's look now and see how the model penal code has changed much of this. The model penal code with incomplete attempts, which all of the line drawing that I've just discussed are talking about, has created what is known as the substantial step. An act or omission constituting a substantial step in a course of conduct planned to culminate in the commission of the offense. Now the question could be, then what is a substantial step? Well, first of all, the substantial step test broadens the scope of liability. It looks to what the defendant has done, not what is still to be done. So what has the defendant done up till now? And as you're going to see, the second part of this test really is what answers the test. To be a substantial step, it must be strongly corroborative of the actor's criminal purpose. So this is the question the jury is going to have to answer. Was the conduct that the defendant engaged in strongly corroborative of their criminal purpose? If it was, the jury will then find that it is a substantial step and that is sufficient conduct to constitute an attempt. Now, the Model Penal Code goes on to state that several things, if they are corroborative, will not, as a matter of law, hinder the jury finding a substantial step. And as you see, they're listed here, and many of them make sense. Lying in wait, enticing or seeking to entice the victim, reconnoitering the scene, unlawful entry, possession of material specifically designed to engage in criminal activity, soliciting an innocent agent to engage in contact constituting an element of the crime. Each of these, if a jury believes that that conduct is strongly corroborative, will not negate the substantial step. But the main focus under the Model Penal Code is whether the conduct that the defendant has already engaged in is strongly corroborative of the actor's criminal purpose. Okay, so let's see our hapless fellow here with his gun. He said, "It is my purpose to kill the professor. I know he is in there. I purposely got the gun, came to his office to shoot him." So the question at common law would be, what still needs to be done, or, depending on the jurisdiction, what has been done? And we would look at the various tests that I have outlined above. Now, under the Model Penal Code, we would ask, is coming to the office with a gun strongly corroborative of the criminal purpose? That is, was it a substantial step that is strongly corroborative of the actor's criminal purpose? And if the jury answers in the affirmative, then this will be found to be an attempt. Now, depending on what the attempt is, it could be an attempt to assault the professor, but here we know that the criminal purpose was to kill the professor. So in this instance, both at common law and under the Model Penal Code, it would be attempted murder. Okay, let's look at some special issues that occur with attempts. There's going to be several of them. The first one is abandonment or withdrawal. Okay. At common law, there was no abandonment or withdrawal from an attempt. Once the defendant has gone far enough to constitute an attempt, the crime is completed. Once the defendant has crossed that magic line that under the various tests that I have previously discussed, the crime is completed and there is no withdrawal. Well, as we've talked earlier, consistent with the Model Penal Code, withdrawal is an affirmative defense under the Model Penal Code. And I've italicized here affirmative defense because that means that the defendant must show by a preponderance of the evidence that the defendant withdrew in order for it to be a defense to the charged attempted crime. Now, the defendant must show that the withdrawal was full and voluntary. It can't be because the crime was more difficult. It can't be because there was an increased risk of getting caught. You'll see in one of the cases I'm going to ask you to read, the Ohio case, where the defendants are on the roof about to rob a place, and they hear sirens in the background. Well, the sirens aren't coming for them, but they leave because they think that the sirens are coming. So that would not be a full and voluntary withdrawal. The second piece to this is that there must be a complete abandonment under circumstances manifesting a complete renunciation. So it must be an abandonment such that the defendant is not going to come back later and do the crime at a different time that is more opportune. So it can't just be postponing. The defendant must indicate in ways that they are completely giving up on their criminal enterprise to be an abandonment. So again, to repeat, at common law there was no abandonment or withdrawal. Under the Model Penal Code, withdrawal is an affirmative defense that must be proven by the defendant, and it must be full and voluntary, and it must manifest a complete renunciation. the next issue, and this one we'll spend some time in class, so don't get too worried about it on the video. Okay, impossibility. Given the nature of attempt. Okay, let's continue with impossibility. Because attempts are not completed crimes, there may be instances where it is factually impossible to complete the offense, as you'll see in a few minutes. Even in these instances, today under the law, impossibility generally will not be a defense. So the issue becomes, with factual impossibility, the facts as they are make it impossible to commit a crime. So this is not a defense today. It used to be, or some of the cases quibbled about whether it could be a defense. So what am we really talking about here? So the goods are not stolen in a situation where the defendant attempts to receive stolen property. The defendant puts his hand in someone's pocket, attempting to take what is in the pocket, but there's nothing there. So is the defendant, the question would be, is the defendant guilty of theft or attempted theft? The defendant shoots into an empty bed, pulls the trigger, points a gun at someone, and pulls the trigger, and the gun is unloaded. In each of these instances, based on the facts, the defendant could not have completed the offense. It would have been impossible to complete the offense. There was nothing to take out of the pocket. There was no one in the bed that the defendant was shooting into. Pulling the trigger on an empty gun would not have fired any bullets into anyone. But in each of these instances, the question is, if the facts as the defendant believed them to be would make the conduct criminal, then impossibility is not a defense. So again, if the defendant believed there was something in the pocket to take, then the defendant would be guilty of attempted theft. If the defendant believed, shooting into the bed, that someone was lying in there, even though the bed was empty, the defendant would be guilty of either attempted assault or attempted murder. Again, pointing a gun at someone and the defendant thinks it's loaded and pulls the trigger, the defendant would be guilty of either an attempted assault or attempted murder, because the facts as the defendant believed them to be would make this out to be a criminal offense. Now, the other half of this is legal impossibility, when the defendant's goal or conduct is not against the law, even if the defendant thinks that it is. Okay, even if the defendant thinks that it is. So again, some examples. Filing income taxes on April 16th, thinking that they are due on the 15th when they are actually due on the 16th. In this instance, the defendant is purposely waiting to the 16th to file his taxes late. He wants to purposely file them late to protest. He has consensual sexual sex with a 16-year-old when the defendant thinks the age of consent is 18. So the defendant has all of the culpability to commit a criminal offense. However, it cannot occur. It is legally impossible for it to occur because in the jurisdiction, for instance, the age of consent is 14. In each instance, no crime can be committed despite the defendant's belief that it is a crime. In this instance, it will be a defense. Legal impossibility is a defense only when all of the facts as the defendant thinks them to be. So the defendant thinks he's committing a crime. However, in reality, there is no crime to commit. Okay, let's talk a bit about what's going to come up as the merger doctrine. One cannot be convicted of both attempt and the completed offense. In most jurisdictions, a defendant can be charged with both attempted murder and murder, but they can only be convicted of one of them. So let's take some examples here. As you know, we've talked already in class about solicitation, so now let's see how this all plays out. I intend to hire you. I intend that you commit the crime. I want to hire you to kill my professor. At this point, the guy with the sunglasses has committed the offense of solicitation. I intend to agree. I intend to kill the professor. I will do it. At this point, we have a conspiracy. Both of these actors are principals in the conspiracy. However, the solicitation now merges with the conspiracy, and both actors will be charged with conspiracy to commit murder if nothing more occurs. Let's go on. Now our hapless fellow shows up at the office. It is my purpose to kill the professor. I purposely got the gun, came to his office to shoot him. So the question becomes, has the defendant at this point, who clearly has the mens rea or culpability for either common law attempted murder or model penal code attempted murder, has he crossed the line for the common law from preparation into perpetration, or has he committed a substantial step that is strongly corroborative under the model penal code? So the question becomes then, has he gone far enough to make this an attempt? So again, now let's continue looking at this. I want to hire you to shoot my professor. So this would be a solicitation if we find the intent to solicit and the intent to commit the offense. I will do it. Okay, so now we have here two principles, assuming we can show the culpability or mens rea needed, to conspiracy. I shot into the professor's office thinking that he was there, but he wasn't. So now we have a principle to attempted murder, because even though it was impossible to kill the professor, the factual impossibility that the professor was not there would not be a defense to attempted murder. And we have an accomplice to attempted murder through the initial solicitation, and conspiracy would make the guy with the sunglasses an accomplice. As we said, the original solicitation merges, but in most jurisdictions, conspiracy does not merge. Now, I'm going to tell you in class that Ohio and some jurisdictions do some things different with this. We'll talk about that then. But at common law and in many jurisdictions, conspiracy does not merge. Okay, one last scenario. I want to hire you to shoot my professor. Again, we remember this is a solicitation. I will do it. Again, now we have two principles to conspiracy. I shot into the office and killed the professor. Okay, in this instance, we have a principle to murder and an accomplice to murder. The solicitation merges and the conspiracy does not merge. So we would charge both of them with conspiracy to commit murder and the offense of murder itself. This concludes this, as I now realize, rather long video presentation on attempt. As usual, you need to go to the TWEN site and fill out the assessment for attempts. Thank you for your patience.